Case on our docket today, the case of Brown versus the state of Florida. Counsel?
Dawn McCready for the appellant Tina Brown. This is an appeal of the Circuit Court's denial of Ms. Brown's motion for post-conviction relief. I'd like to begin my argument today with issue 1 of our brief, the ineffective assistance of counsel at the guilt phase of Ms. Brown's capital trial.
Case on our docket.
This was a case where Ms. Brown's co-defendant, Heather Lee, testified against her at trial.
Counsel?
In exchange for testimony, the state agreed to withdraw the death penalty for the appellant as it related to her. This is an appeal of the Circuit Court's denial of Ms. Brown's motion. Heather Lee's testimony was important in this case. I'd like to begin my argument. She was the only eyewitness to testify at trial as to what occurred in the wooded area when the victim was set on fire. And it was her testimony that allowed the state to argue that Tina Brown was more culpable and that she not only deserved a conviction for first-degree murder, but a sentence of death. So as you can imagine, it was paramount in this case to challenge her credibility and her version of the events that occurred that night. When asked about his defense, trial counsel stated that this was a penalty phase case, not a whodunit case. So by that, he meant that he would argue that Heather Lee was more culpable in the guilt phase, which would then allow him to argue for life for Ms. Brown as being less culpable when they got to the penalty phase. However, trial counsel failed to utilize all of the evidence that was available to him to support this defense. But for these errors by counsel, the results of the proceeding would have been different and Tina Brown would have received a life sentence. So I would like to go through some of what I think are the most important pieces of evidence that trial counsel failed to utilize and discuss why it is we believe the Circuit Court erred in those instances. Now I'll start with probably the most basic tool for cross-examination, prior convictions. And I'll talk briefly about that. Trial counsel failed to impeach Heather Lee with her prior convictions. Now, as a young defense attorney or public defender, the first thing you learn how to do is impeach with prior convictions, because sometimes that's all you have. And frankly, there's no reason not to do so. Trial counsel was put on notice at a deposition by Heather Lee's attorney that she had at least one prior conviction. In fact, she had 2 convictions for felonies and 2 convictions for crimes of dishonesty. When asked about this, trial counsel stated it wouldn't have made any difference. And the Circuit Court agreed and held that Heather Lee's previous criminal record was insignificant under these circumstances. And in the Circuit Court also reasoned that the jury was aware that Ms. Lee had pled to second-degree murder for this case. So essentially, her prior record didn't matter.
Counsel, is it ever a permissible strategic choice under Strickland to not impeach a cooperating witness with evidence of prior convictions?
I would say that's not ever a reasonable strategy, Your Honor, just because it's so simple and it's one of the things that it's included in the jury instructions, Your Honor. So this court approved the jury instructions and thought it important enough to include that as one of the enumerated things to consider that jurors should consider when they're thinking about and relying on or trying to figure out a witness's credibility. So I would say that it's never reasonable to fail to do that.
The problem is, in some instances, the defendant may want to take the stand and testify. And the defendant himself or herself may have a substantial prior criminal record. For that purpose, some defense lawyers basically don't go into the cross-examination of prior records of a witness because the argument's going to be, well, if he's not credible, neither is a defendant because he also has prior records. So there is a strategic reason for not doing that at times. Not saying it happened here,
Well, I think that's pretty risky, Your Honor, to not cross a state witness on their priors, hoping that the state won't bring them up if the defendant testifies. I don't necessarily agree with that reasoning. I think that's pretty risky, especially in a capital case. I would also point out that trial counsel's justification saying it wouldn't have made any difference. This isn't really any strategy, and it's inconsistent with what he actually did at trial with regard to another witness. So the defense called one witness, and within the first couple of questions, he asked her, do you have any prior convictions? How many? And so it's just illogical to think that he thought it was important enough to bring out the priors of his own defense witness, but then not cross-examine the state's star witness who was testifying against Ms. Brown, who was the co-defendant, to not challenge her and cross-examine her on that very same thing. That was just illogical. And again, this is just something so simple that wouldn't have taken much time that he could have done. And especially since he said that part of his strategy was to call Heather Lee a liar. He said, I called her a liar, I don't know how many times during closing. Well, that doesn't matter if you don't have anything to back it up with. And had he put before the jury the fact that she was convicted of 2 crimes of dishonesty, that would have been something that he could have used to support that argument that she wasn't being completely truthful about her involvement in the case. So next, I'd like to move on to motive and bias. And in addition to Heather Lee's obvious interest in the case as the co-defendant, she also had a substantial motive to both murder the victim and to blame Tina Brown. And starting with the victim was sleeping with Heather Lee's husband, and Heather Lee found out about it. And just a few days before the murder, Heather Lee had gotten into a physical altercation with the victim over this affair because she had just found out. Trial counsel had this evidence before him, and he failed to use it to show bias and to show that Heather Lee had a motive to murder this victim. The trial court found that this testimony would have done little to impeach Heather Lee's testimony about being real close friends with the victim. This finding is not based upon competent substantial evidence, and I disagree with that reasoning that it didn't contradict her testimony of being real good friends. It absolutely did. How good of friends were they really if the victim was sleeping with Heather Lee's husband? At trial, Heather Lee portrayed herself as just another victim in this case. She claimed that she was not involved and that she did not participate in the murder. And so her saying that she was good friends with the victim, this was in order for the jury to believe that, if they were such good friends, then they were less likely to believe that that Heather Lee would have participated in this murder. And this evidence would have shown that they weren't on as good terms as she portrayed it to be. Ms. Brown was prejudiced by this failure to present this evidence, because this is also something that the jury should have been able to consider when weighing the evidence and determining the credibility of Heather Lee. And like prior convictions, this is something that's enumerated in the jury instructions to consider. Bias, motive, does the witness have an interest in the case? And she most certainly did. So in addition to the victim, she also had a motive to testify against Ms. Brown and to blame everything on her, which is what she did. Heather Lee admitted in her deposition that she suspected Ms. Brown had been sleeping with her husband. And the trial counsel failed to bring any of this information out before the jury. The circuit court said that there was no evidence that Heather Lee, quote unquote, knew of the affair. But trial counsel still could have cross-examined her on this. Even suspecting that someone's having an affair could be a motive for some people to do crazy things. He could have then always called Darren to confirm that, yes, they were having an affair, because that's what Darren testified to in his deposition. And Darren was Heather Lee's husband. This is something that should have been up to the jury to decide. They should have had this information before them to see that Heather Lee had a substantial motive to murder the victim and to blame everything on Tina Brown. I'd like to talk about two of the impeachment witnesses that could have been called at trial that trial counsel failed to investigate and failed to call at trial in support of his defense. They would have supported his defense that Heather Lee was more culpable and assisted his argument in the penalty phase for a life sentence for Ms. Brown. I'll start with Terrence Woods. So Terrence Woods gave a deposition before trial, and in his deposition, he stated that a few days before the murder, he was over at the trailer belonging to Heather and Darren. He had known them. He was over there, and while he was over there, Heather Lee was outside the trailer, involved in a physical fight with the victim over the affair, because she had just found out that Darren had been sleeping with the victim. At some point, Terrence Woods testifies that Heather Lee barges into the trailer and tells Darren in front of Terrence, I'm going to kill her. She used more colorful language, but I'll tone it down a bit for this hearing. And then a few days after the murder, Terrence Woods stated that he was again back at the trailer with Heather and Darren, and Heather Lee told Darren in front of Terrence that he wouldn't be sleeping with his girlfriend anymore because she killed her. And she admitted that she poured the gas on the victim and set her on fire. The circuit court actually did in this instance find that trial counsel was deficient for not calling Terrence Woods at trial. The court said that trial counsel gave no good reason for failing to do so. However, the circuit court found there was no prejudice because testimony regarding Heather Lee's motive would not have changed the evidence presented that Tina Brown participated in the crime. This downplays the importance of his testimony. Not only did he provide a motive for Heather Lee to murder this victim, but it was also a confession. She said she was going to kill the victim. Days later, after the victim had been murdered, she said that she did it and that she was the one who poured gas on the victim and set her on fire. And it's not, importantly, it's not a matter of whether Ms. Brown participated in the crime, but her relative culpability, right? So that was the whole argument at trial. The state's theory was that Tina Brown was more culpable. And she was deserving of the death penalty. And the defense was that, no, Heather Lee was more culpable. So that was really the issue. So this testimony of Terrence Woods definitely would have assisted trial counsel, would have supported his defense. If he wanted to put as much as he could on Heather, which is what he said, what better way than to use her own words against her? This would most certainly have assisted him in arguing for life for Ms. Brown. The second witness that I'd like to talk about is Darren Lee. So Darren Lee was married to Heather at the time and is actually still married to her. He testified at the evidentiary hearing as to the same information as Terrence Woods regarding Heather Lee's statements both before and after the murder. However, he also testified about a conversation that happened the night of the murder. So after the murder happened, and the people present were Darren, Heather, and Tina. So again, 3 people, no marital privilege. And Heather Lee admitted that she was the one that poured the gas on the victim and set her on fire. His testimony also would have supported trial counsel's defense. Inexplicably, trial counsel stated that he didn't believe this testimony about Heather's confession would have been useful to impeach her credibility. This is not a reasoned strategy. If his defense was to put as much as he could on Heather Lee and argue that she was more culpable, then this testimony would have supported such an argument. There's no reasonable trial attorney who would have forfeited the use of this kind of impeachment material. The the circuit court held that since Darren never made any statements to police and never stated in his deposition that Heather had confessed, then trial counsel couldn't be deficient for failing to call him because he didn't know about the statements. This finding ignores the fact that Ms. Brown also alleged that trial counsel was ineffective for failing to investigate Darren. In that instance, trial court found that because trial counsel was not deficient for failing to investigate because he took the deposition, and that was sufficient. None of these findings are based upon competent substantial evidence. And this court only has to look to the case of Wiggins from the United States Supreme Court that says, in assessing the reasonableness of an attorney's investigation, a court must consider not only the quantum of evidence already known to counsel, but also whether the known evidence would lead a reasonable attorney to investigate further. So I'll explain what I mean by that. And I need to back up a little bit. So Darren was not represented by counsel at his deposition. However, Heather Lee's attorney was present at the deposition, and she instructed him not to answer any questions regarding what Heather Lee may have told him. Now, a layperson's not going to understand the intricacies of marital privilege. And so as a result of this instruction by Heather Lee's attorney, he didn't answer any such questions. At some point after Darren's deposition, Terrence Woods gave a deposition. And in that deposition, as I stated when I was discussing his testimony, he made statements about what Heather Lee said to both him and Darren at the same time. This defeated any marital privilege because a third party was present. This would have led any reasonable attorney to investigate further, to do a motion to redepose in light of this new information. But trial counsel failed to do anything with this. The failure to present a confession by a testifying co-defendant cannot be any sort of reasonable strategy. This would have directly supported his defense of putting as much as he could on Heather and arguing that she was more culpable. The jury never got to hear this very critical information, this powerful information that Heather had planned and then did it. And this was important because the state argued in both the guilt and the penalty phases.
Counsel, I'll bring to your attention that you are now well into your rebuttal time. You've got about 2.5 minutes left.
Okay, Judge, I'll just wrap it up.
You may continue or
Thank
not.
you, Your Honor. So to finish that argument that I was saying, the state argued in both the guilt phase and the penalty phase closings that the person that poured the gas, the person that lit the victim on fire, was the person who actually killed the victim. And that person, in their argument, it was Tina Brown, that person deserved a first-degree conviction and a sentence of death. So that's why this was so important to challenge Heather's credibility about who actually set the victim on fire. That's why that was so critical. And so with that, I will save the remainder of my time for rebuttal. Thank you, Your Honor.
Counsel?
May it please the court, Michael Kennett for the state of Florida. The appellant's argument rests on a faulty premise, and that is this, that the facts of this case would only support one death sentence. But that is just not true. This is a horrific murder, and the facts of this case support a death sentence for each of the 3 individuals involved: the appellant, her daughter, and Heather Lee. Now, it's true that only the appellant received a death sentence, but that's because she was the only one who was eligible to receive a death sentence. Not because the facts didn't support death for the other 2 individuals, but because the law does not. Why? Because the appellant's daughter was not an adult at the time of the murder. Despite the fact that the appellant's daughter watched the victim burn alive and say, "Burn, you know what, burn," the appellant's daughter was ineligible to receive a death sentence, not because of the facts, but because she was a minor. Similarly, Heather Lee was ineligible to receive a death sentence because she pled guilty to a lesser included offense pursuant to a plea agreement with the state. And that second-degree murder conviction made her ineligible for a death sentence. Again, not because the facts wouldn't support it. In In the answer brief on page 80, the state cites this court's decision in Henyard, which clearly supports this position. So what are the facts of this case? And they really weren't explored during the oral argument by the appellant. But it's important to start with the motive of appellant. Prior to this murder, the appellant's daughter got into a fight with the victim. The victim defended herself with a taser. That's an important fact, a taser. So a few days later, the appellant and the co-defendants lure the victim into appellant's trailer. It's the appellant's trailer under false pretenses. Let's make up. Let's be friends again. When the victim arrives, it is the appellant who tases the victim repeatedly. And we know this because it's the appellant's DNA that was on the taser. So after the appellant repeatedly tased the victim, the appellant dragged the victim to another area of the home and beat her. They then dragged the victim to appellant's car. Again, it's appellant's car, and the victim's DNA was in appellant's car. Appellant drove the victim and the other two defendants to a remote location where the appellant dragged the victim out of the car. When the victim tried to escape, the appellant and the appellant's daughter grabbed her, subdued her, and then beat her and tased her again. First, the appellant tased while the appellant's daughter beat the victim with a crowbar. Then they switched weapons so that the appellant could use the crowbar and the appellant's daughter could use the taser. Then the appellant went to her car, got a gas can, came back, doused the victim with gasoline, lit her on fire. These are horrific facts that would support a death sentence for any defendant who was a participant in this murder. And we know that it was a planned murder because before all this started, the appellant's daughter told her teenage friend, "We're fixing to kill Audreanna." There is no doubt of a group intent here. And there's no doubt about guilt as to first-degree premeditated murder or first-degree felony murder. As the trial counsel correctly said, this is not a whodunit case. Additionally, the appellant confessed to two different individuals. One, Corey Doyle, who was in Escambia County Jail at the same time as the appellant, and then also Pamela Valley. And Pamela Valley said that the appellant solicited her to finish off the victim when the victim was in a hospital. So there's no doubt about the appellant's guilt, and that culpability is sufficient for a conviction for first-degree murder, and it is sufficient for a death sentence, despite any missed opportunities to impeach Heather Lee. And I would note that Heather Lee was impeached through the testimony of Wendy Moy, who was an inmate at the Escambia County Jail at the same time as Heather Lee. And Ms. Moy testified that Heather Lee confessed to Ms. Moy that she was the one who doused the victim with gas. But it doesn't matter. It's impeachment evidence. And again, as the trial court correctly found, there's absolutely no possibility for prejudice in this case.
Counsel, I'm sorry to interrupt you. It seems like the other side's argument really turns on not so much in the abstract as to what the state could have argued about, the fact that participating in all those ways would have made the defendant culpable enough to justify the death penalty, but that it's tied more to the specific arguments that were made and the emphasis on the fact that it was the appellant who lit the victim on fire. Could you address just how much, to what extent was that specific reason, at the heart of the argument for giving a death sentence here?
Well, certainly the state wants to put its strongest argument forth possible, and the evidence at trial from Heather Lee was that it was the appellant who dragged the victim out of the car. It was the appellant who doused the victim with gasoline. It was the appellant who lit the victim on fire. So yes, certainly the state is going to go with its strongest argument that is supported by the evidence. But we're in post-conviction. There are significant finality interests here, and this is just simply not enough to overturn the conviction or the death sentence because the evidence of guilt is overwhelming and the evidence of aggravation is also overwhelming. Again, they burned the victim alive. And what makes this case unique is that here you have the victim of a murder who identified the people who murdered her. That doesn't happen very often in a murder case.
But I think the test, though, is if you assume if the deficient performance prong is met, then the question becomes: is there a reasonable probability that had the impeachment been done of Heather Lee, that the defendant would not have gotten a death sentence? I mean, that's the legal question in front of us, right?
It is, and there's just no materiality. There's no prejudice possible given the facts of this case. And again, I'll go back to this court's decision in Henyard, where there was a dispute about who was the actual trigger person. But both defendants had substantial culpability, and they were substantially involved in that crime, to include underlying crimes of carjacking and rape in that case. And here we have the underlying crime of the batteries, the aggravated batteries, and the kidnapping with the asportation. So there's just too much involvement by the appellant. Again, it's her trailer, it's her car, and we have appellant's two separate confessions. And as part of one of those confessions, she solicited someone to finish off the victim. So even with the impeachment of, even with additional impeachment, because Heather Lee was impeached, even with additional impeachment, it would not have changed the outcome either.
And I'm sorry. Can you remind me? I can't remember from the record where did the confession specifically involve the defendant saying that she was the one who lit the victim on fire, or is it more generally that, you know, I participated in killing this person?
There's some suggestion that the first one to Corey Doyle might have been a we, but the one to Pamela Valley was more of an I, because she solicited the appellant solicited Pamela Valley to finish off the victim. So there does appear to be a we for one and an I for the second. But even if it's just a we, as the trial court correctly found, there is significant group intent, and the trial court highlighted.
Let me do just to clarify. You would agree that it was only Heather Lee who specifically said after the fact to witnesses that she was the one who lit the match and burned the victim.
Right, and there was a suggestion.
Brown never said that to anybody.
No, Brown did confess to both Corey Doyle and to Pamela Valley. And again, she asked Pamela Valley to finish off killing the victim. So that's sufficient. And the trial court found that there was sufficient group intent here, going back to the comments from the appellant's daughter to the teenager who was also present before the attack started, which is, we are fixing to kill Audreanna. At that point, given everyone's involvement, like I said at the start, the facts of this case support a death sentence for each of the three. There wasn't just one death sentence to hand out in this case. And I'll briefly touch on, even though it wasn't mentioned, the ineffectiveness assistance claim for the penalty phase, just to highlight that all of the ACE factors, all 10, there are facts in this court's opinion on direct appeal that would support all 10 ACE factors. And there was evidence to link appellant's childhood trauma to her development. There was also evidence to link her cocaine use to her brain development. And I'll just very quickly, this is from this court's opinion on direct appeal. Dr. Bailey is a defense witness. Dr. Bailey testified that Brown's parents were neglectful and provided an inadequate and unhealthy foundation, which negatively impacted Brown's development. So there's a link between the trauma, the childhood traumas, and there's additional, I won't waste the court's time, but there's a link between the childhood trauma and the appellant's development. And then if you look at some of the non-statutory or the catch-all mitigators that were found by the trial court, one of them was that the appellant suffered from drug addiction throughout her entire life, and that the long-term effects of the chronic cocaine use impacted her brain. So again, there was a link between a childhood trauma and the appellant's development, as well as the chronic cocaine use and appellant's development. There was no deficient performance in the penalty phase. Thank you. The state asks that this court affirm.
Rebuttal?
Yes, Your Honor, thank you. And I know I have just limited time here, so I would just like to hit on some of the points that counsel just stated that need clarification. So when he said that when they were in the trailer initially and Brittany, Ms. Brown's daughter, said to Mallory, "We're fixing to kill Audreanna," Ms. Brown was not in the room when that happened, and that's clear from the record. Her and Heather Lee were not in the room, and there's no evidence that she knew what they were, quote, fixing to do. There's just simply no evidence of that in the record.
Counsel, you don't dispute the fact that is your argument really focused on what the state emphasized with regard to culpability? Because I mean, you're not disputing that given these horrific facts that your client the reasonable person could have found that your client deserved the death penalty, right?
Justice, you are right. The focus of my argument today is on the culpability. I think that was an important issue because that's in trial counsel stating that this wasn't a whodunit case, this was penalty phase. So it all rested on who was more culpable. And I would also point out that, as Your Honor said, it does come down to who set the victim on fire. That is what the state argued in the trial, at the guilt phase of the trial, as well as penalty phase. They really harped on that, that part. And all of the evidence put forth about what happened in the wooded area, all of the evidence about who set who on fire, who did what, came from Heather Lee, who has a substantial interest in this case. And trial counsel's performance in this case was simply—
What wasn't the evidence from—
I'm sorry?
Wasn't the dying declaration of the victim that they set me on fire? And maybe be specific.
She said, Heather and Tina did this to me. Yeah. Yes. So she didn't specify who did what either. The only person to specify, or the only person to testify that Tina poured the gas and set her on fire, that testimony came from Heather and Heather alone. And that's why it was so important in this case to challenge her, her story with her inconsistent statements, with her prior convictions, with her interest in the case and her bias against the victim and Ms. Brown. All of that was critical. And trial counsel's performance in this case is not what was envisioned by Strickland. And as a result, Ms. Brown was incredibly prejudiced by his performance. And had he done all these things, had he impeached the co-defendant, the state's star witness against her, Ms. Brown would have received a life sentence. And so I would just ask this court to grant Ms. Brown a new trial and or a new penalty phase. Thank you.
Thank you. We thank you both for your arguments in this case, and that concludes this session of court. The court is now adjourned.